On behalf of the Upstate New York Towns Association, I'd like to welcome you this evening. We're very happy to be able to present this program on what municipalities need to know about solar farms. And certainly solar farms can make a significant contribution to electricity generation. And I believe that most towns or all towns are supportive of solar farms, and we want to know more about how we can do this the right way. The program is being presented by the Joint Landowners Coalition, and we have 4 presenters this evening who will present. What we ask is that you hold your questions until the 4 presenters have finished. So you might want to jot down some questions. The first presenter is Bob Williams, and Bob is the Director of Environmental Studies for Barnes-Williams Environmental Services in Binghamton. He has over 45 years experience in environmental assessment and impact work, and extensive experience in permitting environmental compliance monitoring. He's going to be speaking on environmental issues related to solar farms. He will also be speaking about the seeker process as it is related, and the New York State United Solar Permit. Bob, I'm going to turn it over to you.
Sure. Thanks, Carolyn. I'm a local guy. I've lived in Binghamton off and on most of my life. I'm just going to embellish a little bit on what she said. I actually started working in the environmental field in 1968. That's 4 years before the Clean Water Act. And in New York State, the only regulatory agency that was doing anything at the time was the Public Service Commission. I also outdate the Environmental Protection Agency too. But I've done a lot of this. I've worked on a lot of projects that have to do with renewable resources. In New York State alone, I've done the environmental work for 32 hydroelectric projects. And if anybody tells you in New York State that hydroelectric is going to be a big boost for renewables, believe me when I tell you that most of the good spots have already been taken. Anything that's left to do now isn't there because it's not any good. Like, for example, in Binghamton, the Rock Bottom Dam. Why doesn't the Rock Bottom Dam have hydropower on it? Well, first off, there's not enough elevation difference called head between the top and the bottom. And the river's so flashy that when we do get a lot of water, the Shenango floods it out into what would be the tail race. So that site will never be developed. Unless we could actually raise the dam, but where Dan Fitzsimmons lived, he probably wouldn't like that very much because we would put Conklin underwater, so that's not going to happen. But anyway, I wanted to talk to you briefly about the solar stuff and how we got involved in it and what we're doing. Up on the screen here, I have the Cornell University solar plant, and this is actually a pretty nice situation. It's right here, this one down here, and Jim and I went up and looked at it, and he'll tell you more about it. But, see if I go in the right direction. We got involved in this because on January 25th, the public service staff came out with a white paper that's going to develop mandates for what we have to do in New York State. A couple of common terms that we'll all be talking about as we go along. One is a kilowatt, and that's 1,000 watts. That's what you see on your electric bill. That's what you pay for, kilowatts. 1,000 times that is a megawatt, and what you end up with when you're dealing with the solar farms is you deal with their megawatt capacity. You hear about megawatt capacity. And the Cornell University one that we just had the picture of here is a 2 megawatt, has a 2 megawatt capacity. That doesn't mean it generates 2 megawatts all the time. That means it has a 2 megawatt capacity. And if you look at a typical power station, I don't know, the 9 Mile Point nuclear power station has 1,900 megawatt capacity, but it develops 1,900 megawatts 24/7 if it wants to. There's no down and up and stuff. They can just go forever. And the other one in here is a gigawatt. A gigawatt hour is 1,000 times a megawatt, and this is what you need to generate a gigawatt if you're going to be involved in SRECs, which is a payment that you get for doing this. And Jim will talk more about that because that's the financial stuff. Jim and I went up to the solar farm. We decided to run up in February. So we ran up to Cornell. It just happened to be the night before. We got like an inch of snow. So this is the Cornell University solar farm in February with an inch of snow on it. And how much electricity was it generating? That's right, nothing. Nothing. It wasn't generating anything. But in order to do this, on the state renewable energy goals, New York by 2020 wants to increase the output using solar 3,929 gigawatt hours. That's a lot. That's a lot. In order to generate a gigawatt hour, you're going to have to run one of these power stations. If you use 5 acres to develop 1 megawatt, and you got to have 1,000 megawatt hours to get a gigawatt. For the 2020 goal, it's going to take like 19,000 acres of solar to achieve that goal. 19,000 acres of solar. That's where I started looking at it and said, whoa, wait a second. That's a lot. If we're going to do 19,000 acres, shouldn't we be looking at something? And this is where we get involved with the town stuff. One of the things that happens, if you're going to develop 19,000 acres, that's a lot of acres. That is a lot. That's a lot of things. What's going to happen is everything has some kind of environmental impact. Everything has some kind of environmental impact. And what's happening now with the solar build out is that the evaluation of the environmental impact is going to be your cars, yours. I happen to be on the Town of Windsor Zoning Board of Appeals. Carolyn actually talked me into it, and I don't know if I'll ever forgive her. But I'll tell you what, being on the Zoning Board of Appeals, I want the zoning and everything to be so good that none of these projects ever come to me. I don't want to have to make that decision, whether you can put it in or not. But anyway, so the environmental issues are the same for this as they are for any large project. And this is a large project. You've got wetlands, which are going to be regulated by the federal or state government, water bodies and streams, federal and state government, they all have to be examined every time. Threatened and endangered species, you can't get around it. Stormwater discharge permits, anything over an acre has to have a stormwater discharge permit. It's a big deal. The seeker state, which includes cultural resources, you have to do the cultural resources on every one of these sites, and local. Now, I don't know, from my viewpoint, I don't think it's actually fair because these sites are all alike. You're going to put a 10-acre solar farm here, you're going to put a 10-acre solar farm there. We've already have with one company has over 900 leases out, 900 leases for these solar farms in New York State already. And so if they're so similar, this is the part where the state should go back and do the same thing that they did with the oil and gas, where they did the supplemental generic environmental statement. The seeker process allows for a generic environmental statement. And if they do a generic environmental statement because you're putting 10 acres of solar panels here, and 10 acres of solar panels there, and 20 acres of solar panels over there, a lot of the impact is going to be exactly the same. I'm going to say probably from a town-to-town situation, probably 80 to 90% of the impact will be exactly the same. You're going to put these in this way, this is how the bases are going to be, the road traffic's going to be this, it's going to be how many trucks are going to come in and how they're going to do it. It's going to be the same. That stuff should be all laid out so that we don't have to deal with it on a town-by-town basis. So that when the project comes to you, you look at the generic environmental statement and then you say, okay, we still have this issue to deal with. We've got this issue in Sanford to deal with. We've got this issue in Johnson City to deal with. But there'll be a few things that'll be different. But it's a heck of a lot easier if you're only dealing with a few things than if you're dealing with the entire situation. One of the things that's kind of interesting about the seeker law, you have type 1 actions and type 2 actions. And if you have something that's over 10 acres, it's a type 1 action. That requires an environmental impact statement. If I were the environmental consultant for someone putting in one of these things, I would say, let's go out and look at our 9.99 acre project. It wouldn't be a 10-acre project. It would be just under that, because then I could argue for it being a type 2 action. In a type 2 action, you pull out that seeker form and you go through. Will there be any problems with traffic? And yet, no. Will there be any significant environmental impacts? No. You just go down through this checklist. And you're not required to do it unless the town, of course, the town can come back and ask you to do an environmental impact statement. But I think that the one place where the state has, they pushed this thing forward so fast that they didn't allow us, they haven't thought about us. More environmental issues, land use changes. I've lived here a long time, and I can remember where, I live in the town of Windsor, I can remember where a lot of the town of Windsor was farmland. And most of that farmland now is covered with trees. The land that's not covered with trees in the town of Windsor still is farmland. So if you look around and it's like pretty much all trees, it's farmland. So in my town, when they put in any one of these projects, it's going to be, they're going to cut down a lot of trees, or they're going to take something that's still farmland. And those are huge environmental issues, because you've got land use changes, and in our lifetime, it will never change, because once they put one of these in, it's in for a long time. Decommissioning, that's a huge problem. After this thing's been in for 20, 25, 30 years, however, at some point, they're going to either want to change it or they're going to take it down. Now, when they take it down, who's paying for that? Scott's going to get into this later on, I'm not going to. Land restoration, and with the decommissioning comes bringing the land back. Now, if it's a simple process where they just drive posts into the ground and hook it to them, that's good. But a lot of these places where the land's not quite good enough, they have to put concrete in the ground before they put them on. Putting the land back when you've got concrete foundations, not so easy. And of course, everybody will come to you guys because they'll say, I have a solar farm in going next to me, and it's killing my land values. I look out over there and all I get is the glare. It's killing me. I mean, these are issues that we're going to have to deal with, and they're environmental issues. All right, now I'm going to tell you the landowner rules. These are my landowner rules. If you have someone coming in to you and they say that someone wants to put a solar farm in, you should tell these things that if someone's going on their land and they're going to do any kind of surveys, you should have a limited license, and somebody like Scott can help you with that. So that once they go on the land, they tell you exactly what they're planning to do on the land, what they're surveying for, how long they're going to be there, and make sure they have insurance before they're out walking around on your land. Make sure that they're insured. And the other thing is the landowner should get copies of all the surveys. He should have copies of everything, just to protect himself. And last but not least, for me, and then we're going to skip on to Jim, is some good sites for information. These are good places to look. The first one is the National Renewable Energy Laboratory, of course, it's Department of Environmental Conservation, Public Service, and NYSERDA. The other one is kind of interesting, which is a new site, and it's primarily for rooftop solar. Now, we're not talking about rooftop solar here. We're talking about big projects. The Project Sunroof, which is a Google site, which is really kind of cool, and they've actually included most of the Binghamton metropolitan area in their database, and you can actually go on it and you can type in your address, and all of a sudden a picture of your house comes up from the, and they'll analyze it for shading, and they'll tell you how many useful hours of sunlight you can expect to have per year based on all kinds of data from our area. They'll tell you how much it will cost you if you lease the solar panels, how much you need on your roof, how much it will cost you if you buy the solar panels, and they'll tell you how much, whether you make money or lose money over how much time. It's a cute site, and it's a good place to start if you're thinking about solar for your roof. But I'm done, and I'll be here with questions later.
Thank you, Bob.
You're welcome.
Our next presenter is Jim Leonard, and Jim is a CPA who worked for 37 years in the Endicott area, recently retired, but still very involved. And he's also done a lot of work in the area of wind and solar. And he's going to speak with us about financing solar farms.
This is an insolation map. It's kind of like a solar map. You know, you've probably seen the wind maps and so forth. The first question I had when I found out that all these companies wanted to come in and lease from us, so I'm looking at this map and I say, really? I'm looking up at New York. And it's like, okay, what's going on with this? So it's like, it doesn't make sense. If we were in Nevada or Utah or something like that, it would certainly make sense. But for upstate New York, I mean, I don't have to tell you, we don't have the best sunshine here. So what do you guys think is the real driver here? Tax incentives. There's a bunch of things going on, but basically, it's all about the upfront money. Here's the federal incentives. You have 30% of investment tax credit. That's incredible. I mean, you just don't see numbers like that very often. Plus, you get to write off half of the cost of the project in the first year, very first year. The rest of it you can write off over the next 5 years, or during the 5-year period. So after 5 years, these companies, don't want to get too confusing here, but there's a tax equity partner who typically will get involved with this, and they're the ones that will use this. But after 5 years, they have no reason to be there anymore. So, not uncommon to see them leave and sell the project back to the original developer. Bob mentioned about the SRECs. What's really driving this, and we'll find out in New York maybe next week, is how fast do they want to get all of these solar panels built. So the PSC is going to set up the demand, which is going to be, okay, if you want to get to 50 by the year 2030, we want to go in steps to get there. So we may be at, say, 20% in the year 2020 and so forth. So there's different steps. That establishes the demand. So now, once you have the demand, the companies that are actually generating this electricity can go sell the market. The utilities have to buy them. So if they have to have 30% of their electricity from renewables, they're not going to go out and build them, but they can buy credits for what somebody else is generating. And these SRECs can be very, very valuable to the companies. Here's the revenue. Here's your cash flows. The revenue from electricity sales actually is pretty nominal. The real revenue is the SREC sales. The electricity, you may sell it for, what we just looked the other day about, what, do you think 6 cents a kilowatt on average? For
Six and a half.
Decent number.
Yeah.
The SREC sales worked out, we checked the New Jersey site, and that was 29 cents a kilowatt. And what was the other one?
Massachusetts.
27 and a half cents a kilowatt. So you can tell, I mean, that's where the real money is going to come from these guys. So that's what's driving all of this production here. The expenses, you have operations and maintenance, which is nominal. I mean, other than mowing the lawn or spreading herbicides, whatever they do to keep the weeds down. The real expense is going to be the lease payment to the tax equity partner. That's where the real nut is. And then there's a whole issue of property taxes. I don't want to step on your toe. You guys could be talking about that a little bit. Property taxes is, that's a key issue. But basically, they're looking, the real money is going to be in the SRECs plus these tax advantages. So in the future, in 5 years, all the tax benefits are going to be fully earned. There's nothing more for the tax equity partner to gain. So they want to get out of it. So they'll sell it back to the original developer. In 15 years, if there is a property tax exemption, that's going to be gone anyway. But at some point, the value of these SRECs is going to be greatly diminished. The whole point of the SRECs is basically a demand by the state government. They want to get so much solar power by a certain period of time. But at some point, it's going to be fully built out. So those SRECs gradually are going to lose value. They'll slowly come down. And then basically, at that point, what's it going to look like to the operator, and what will the farms look like without maintenance? This is probably the last thing you want to see in your towns. Okay? This is not good. Here's the same farm that we were talking about before up at Cornell. I was curious. If you go on the NYSERDA website, you can see, you can download the performance of every solar farm in the state, and in terms of how many kilowatt hours are generated. And this was for the year of 2015, the entire calendar year. And it was supposed to be rated to bring in something around 2.5 million kilowatt hours. It came in less than that, at 2.1. Multiply it by the 6 cents that we were using. This whole thing would generate the equivalent of $127,000 a year in revenue. This I just got off from the Cornell website yesterday, and it's saying the overall cost is about $4 million. The NYSERDA award was about 1/3 of the project cost. NYSERDA is an acronym for you and me. So Basically, they had to go out and finance it, so they're not, NYSERDA is not going to continue to dole out tons of money. They're going to run out eventually. So I took the $127,000 for the revenue. Here's a $4 million projected cost, and I looked at, okay, let's say we finance that for 15 years. I talked to some of my banker friends, and they say for a commercial project, 15 is about as far as they're willing to go out, even for a company with excellent credit. So we go 15 years, and I didn't factor any interest. All I did is just take $4 million divided by 15. You've got a cost there of $267,000 a year. Your revenue from electricity is only $127,000. So you can see they're very, very, very dependent on the sale of those SRECs. And you know, because that's the way the game is structured, those SRECs are going to decline in value over time. That's how the whole plan works. So you have, to me, kind of a sitting time bomb here, at least financially. Here's the day that Bob and I were up there. This is a graph from that NYSERDA website I was talking about. And this was the very, very, very best day in the life of this particular farm. And you see it hit a high of 1.8 megawatts. So it was only 90% of its rated capacity on its very, very best day. What I'm intrigued about is, what about all of these hours in the middle of the night when there's no electricity being generated and there's no wind outside? So we gave a talk up in Ithaca, and I kind of asked the question, what are you going to do for heat and light and electricity? I never really got an answer. Now, here's the same numbers. This is very interesting. This is all production from day one. They commissioned it back in September of 2014. But you notice this little empty spot here? That was in February of 2015. If you remember, February 2015 was very cold. We had a lot of snow. And you can see how much electricity that solar farm created. During the coldest month, when you need electricity and you have long nights, you have lights on and everything, it's just not there. And by the way, it was with that little inch of snow, probably wasn't even an inch of snow. It only generated 55 kilowatt hours during we were there at noon, high noon. 55 kilowatt hours, nothing. It wouldn't even register. But this is what I'm thinking. I think down the road there's going to be some utility pushback because of this. If you have 1,000 of these 2 megawatt farms, that's 2 gigabytes. That's the equivalent of what?
Nuclear, 9
Mile Point. Okay. And so basically, if you're the NYSEGs of the world, or Iberdrola, and you got a great sunny day, and all of a sudden you're going to have all this power coming up, because that's the equivalent to a nuclear power plant coming online, and then suddenly going offline. Like, how are you going to adjust to that? I mean, it's got to be driving these utilities crazy. And I know in Vermont, I was just there last month, I was talking with some people, I said the utilities are definitely pushing back on what's happening up there. Of course, the ratepayer pushback, those SRECs we were talking about, guess who pays for those? The ratepayers. Okay, it's just buried in the bill. So it's a lot, the SRECs are very, very expensive compared to the cost of the electricity that's being generated, but you're not really going to notice it in your bill because solar just makes up such a tiny part of our overall electrical bill. So as you build more and more of these solar farms on, that's certainly going to change. And of course, taxpayer pushback. If they start seeing some of these solar farms that aren't being maintained anymore, and you have stuff that's growing through, taxpayers are not going to be very happy about the whole concept here. And that's all I have. Thank you.
Thank you, Jim. Our speakers are giving us a lot to think about, aren't they? I'm sure you're going to have a lot of questions. Our next speaker is Scott Kurkoski, who is a partner in the law firm of Levine, Golden & Thompson, located in Vestal. He's chair of the firm's Energy Practice Group. He's also chair of the Broome County Bar Association Energy Committee, and he is the attorney for the Joint Landowners Coalition. He's going to talk about what's happening with leasing for solar farms. Scott?
Thank you, Carolyn. Hello everyone, how are you? So we want to talk a little bit about what's happening right now, what landowners are dealing with respect to these issues, and how those issues affect you as municipalities, because I think primarily our concern is to make sure that the landowners and the communities are protected as we move forward with the state's plan to achieve 50% renewables by 2030. That's the goal that the state has set, 50 by 30. So what we do see is we see a lot of incentives that are there by the state and certainly the federal government to produce renewable energy in New York. And we often hear from NYSERDA and others that we have to be careful about the cost because as Jim just described, right, these are pretty tight margins. And this only works if all the numbers come together correctly. And so as communities and as landowners, we have to keep those things in mind. What happens when things don't work? So we hope for the best, but we prepare for the worst. Sometimes I get accused by my clients when I'm putting together their new businesses of being too down on what might happen. I'm like, but this is the thing that happens. People pass away, companies go out of business, companies file bankruptcy, and we have to make sure that we understand those issues and we are preparing for them in advance. Right now, we are seeing this massive land grab going on in New York. Sullivan County reports that their landowners received 6,500 letters from solar companies. We know that one company has signed probably 900 to 1,000 leases right now. And what's interesting is that oftentimes as I'm negotiating these leases with landowners, I'll contact the municipality, talk to the town and say, look, what laws do you have in place so that I can kind of factor those laws into what I'm doing with respect to negotiating the lease. And more often than not, I'll hear, we didn't really know this was going on, or we didn't know that our landowners were being contacted. And I'm really surprised at that. And I'm certainly hearing most of the time that we're not yet quite ready. We don't have our laws in place. Some towns have put in place moratoriums. Other towns are making decisions with respect to real property tax assessments and permits and things like that. But these are all the things that you need to start looking at and figuring out how are we going to be addressing these issues. The economic issues are crucial because we can certainly, as municipalities, add various protections to the town and to landowners. But as you add each one of those, the economics for the companies change. So as municipalities, you're going to have to look at these issues and decide, where do we want to fall on this? How much incentive do we want to provide to bring these companies into our town for development? And how much protection do we want to provide for our towns? What happens when we get stuck with a project that we have a company that now has gone bankrupt, a landowner who is no longer there or paying the taxes? What happens to us? I mean, you know what happens in those cases, but you've seen it in some of the flood cases, but for the floods, and but for the federal help, you'd be lost. You add some of those to special assessments, they don't pay, then they end up where the county is looking at those properties afterwards. So those are all the issues that I think that you need to think about, and we'll talk about them more, and Brady's going to especially touch on a lot of the issues that the municipalities grapple with. I would also encourage everyone to attend other workshops that are out there. New York Sun is putting on a number of programs. They have their PV trainers that are out there talking about these issues. Bob, Brady, and I just attended one yesterday, and actually it was a very good program. It was extremely informative. It talked about all of the issues that I think many of us are trying to address, but I thought they did a great job. They didn't really address a lot of the issues, though, about what happens when things don't go the way that we had hoped. And certainly questions about bonding, should there be bonds for these projects? Questions about whether these companies are going to make it or not. We know, for instance, that SunEdison is a great company to deal with. I had great experience with them in negotiating a lot of my leases. But SunEdison just last month filed a bankruptcy. It's a massive bankruptcy. And so those are the types of things that you're going to see, and especially in this industry where the margins are so tight, the risk of that is high. Also, I wanted to mention that on June 29th at the Shenango Town Hall, 9:30 to 11:30, Jessica Bacher will be speaking on zoning issues. So I think some of us are going to attend that too. Jessica is part of the Pace University Law School Land Use Planning Department. So that might be helpful to you as you consider.
Where is that?
It's at the Town of Shenango, June 29th at 9:30.
You have to go online and sign up.
You do, right. So, when a landowner comes to me to start looking at one of these leases, what I start talking to them about is this something that you want to do? And these are the things we have to start thinking about, right? What happens to my property value? Well, if I've got a 50-acre solar farm, right, am I going to be able to sell that 50-acre solar farm in the foreseeable future? Do I really want to lock up 40 acres, 20 acres, whatever it is that final solar array ends up? I want to lock up that amount of land for probably 40 years. And by the way, those are the types of leases that we're seeing. We're seeing leases that are coming in at 20 years with the ability to extend for an additional 20 at various stages. Oftentimes the discretion to extend is entirely with the company itself. But these leases are lasting 40 years. So I want to make sure everybody here knows exactly what they're going to be doing in 40 years when these things finish up on their lease. That's the way you need to be thinking about it, right? Because it's great now that we're bringing in renewable energy to the state, and I think all of us recognize that that's important to our state, to our towns, to our country, but we also need to make sure that we're planning for what might happen down the road, right? Again, if the companies don't make it, or if solar energy is just not the energy of the day anymore. If we decide to go in a different route, what's going to happen with those projects now that we're not using solar? We've got some other alternative energy that we decide that we want to use more. So we looked at property values. What's going to happen to my neighbor's property value? That might be a concern. What about financing issues for me? If I need to go out and finance, get a loan for like a home equity loan, will that be an issue? And it's funny, but we're seeing, get hundreds of calls on solar leases. On every single one that I'm getting, there are no mortgages on the property. And I think primarily that's because the companies are looking at this in advance, and they know they don't want to have to deal with the bank on these issues. So now they get their solar lease, and everything else that follows is going to be subject to that solar lease because it'll have first priority. When there's a bank involved, the solar company comes in, they're typically going to want to do things like get agreements that subordinate that solar lease, and some lenders are helpful with that, some are not. But again, most of the ones, actually every single one that I've seen is a property where there's no mortgage on that property. Understand that a solar farm is a commercial use. So if you've got an agricultural assessment, that solar farm is going to affect that assessment. So your landowner has to understand how that is going to impact them. Right, it's key. There's going to be a rollback for that commercial use on the tax benefit that the landowner has received from that agricultural assessment. And the penalty is 5 times the tax savings that they received in the previous year, plus another 6% per year for a maximum of 5 years. So the rollback penalties are big when you convert that agricultural property to a commercial property. It does just govern the piece of property that we're talking about, but if we're talking about a 50-acre solar farm, then that penalty is going to be massive. There, it's really key that we're making sure that we are covering those issues in that lease so that the company that's coming in is not only paying the taxes on the property that it's using, and that's how they typically work. So they don't typically have an issue with that, where they're paying the taxes on the portion of the property that's set up for the solar array. But what we then do is we're saying that any other increases that are attributable to that project, we need to make sure that that company is paying them and that they don't go on to the landowner. And this rollback penalty for that loss of the agricultural assessment is a big one. Things like 480A forest programs, there's another one where there'll be a rollback penalty. Any sort of violation of a conservation easement that could have a penalty. Those types of things all need to be addressed in that lease document to make sure that they're protected. So, and also, for the landowner, what's my current use, right? So, if I've got the tree farm, that's going to be a major issue. If I'm using the property as a quarry, gravel pit, actually just had someone that is using their property as a fish farm, where they're growing fish. And eventually they decided, this use isn't really going to be compatible with the particular use that I'm going to have, and they were concerned about being able to continue that use into the future. So those are all things that we want to take a close look at. Now, typically the way that these leases will start is a company will come in, sign the lease. Again, a lot of these leases are being signed for very low upfront payments, maybe $250, $500, not per acre, but flat fees. That's what you get into on the lease. And then the company will start their due diligence period. It could be a 6-month due diligence period, it could be as much as a year or 2 years, but then they'll start that due diligence period to try to figure out, are there plans for this solar farm going to work in that particular town? That's when they're going to come to you. They're going to want to find out what are the regulations in your town, what requirements are they going to have, and what additional costs will the town impose to their project. Those are all things that they're going to want to do, in addition to getting other approvals from the utilities and others, and looking at some of the zoning issues. Those are all the things that the company will have to do during that due diligence period. And eventually, if they decide that this is a project they want to go forward with, they'll start with that construction phase, commence the lease, and then start paying the landowner a lease payment. So it's only at that point that they'll go forward. If they decide that they don't want to move forward into that construction phase, then they simply just terminate the lease. But again, that is all within the discretion of the company at that point. We're seeing lease payments in the range of $1,000 to $1,500 per acre per year. So that's not too bad. But a landowner's got to look at that and compare that to the potential loss in the value of the property. Are they going to recoup that value over time? And for a lot of landowners, they're looking at that saying, yes, they are. But I caution my landowners initially up front, because I've had some who are already making plans to maybe stop dairy farming, for instance, as soon as they sign the lease. I'm telling them, don't do that. I mean, you could go 2 years under this due diligence period, and the company decides that they're not going to move forward with the project, and then you're right back to where you started. So I'll caution the landowners all the time on those issues. So the big issue that we're always addressing on our leases is the reclamation issue. And this again is where I'm often contacting the towns. I will tell you that we work on detailed reclamation plans on all of our leases. But what happens when the company does not perform them, right? That's really a key for us in the negotiations. First, we want to make sure that if the company doesn't live up to their obligations, we at least have got the ability to step in, take over, get rid of some of those things on our own and sell them, dispose of them, do something along the way. Disposal, by the way, is one of those other issues that the state hasn't really talked about too much. Right now, there are no landfills in New York that accept solar panels. So what happens at the end of a 40-year lease when we have to dispose of the panels? These panels are they're rated for about 20 years, right?
Yeah, maybe 25 or 30.
So they could be 20, as long as they're working. And the ones that are not working, we'll have to do something with them. That something could be that they're recycled and used in other ways. It could simply be that they're sold to other companies, where those companies come in. But you understand that whatever it is, someone is going to have that burden of taking care of this project. How are we going to handle that? So I would love to be able to get a reclamation bond or a removal bond in every single one of my leases. We're not getting them. And that's when I turn to the town, and I hope that the town has put together something that says, hey, when we issue a building permit, we're also going to require a removal bond. That's always very helpful. And if I don't get that from a town, and I'm not getting that too often yet, by the way, but if I don't get that, then the discussion that I have with my landowner is, okay, here's what we've been able to accomplish in our negotiations, but here's where your potential risk is. And at the end of this project, if it turns out that there is no one to take care of the panels, the company's gone out of business for some reason, then that is going to be on you, and it doesn't look as though that the municipality has set anything up to help you along with this process. Now, that's, in my view, unusual that the state has put together this program and said, you have to take care of those issues, right? And if you take a look at the other things that we do in the state, it's really not that way. If I want to put a quarry on my property, I've got to have a reclamation plan, and I've got to have a bond, and I have the DEC monitoring the process the entire way. You will not see that in New York state law. We're talking to New York State about those issues, suggesting that these are issues that should be addressed at the state level instead of at the local level. But until that happens, we really have to address it either in the lease documents, and as I'm telling you, we're not accomplishing the reclamation bonds there, so the only opportunity to get that accomplished is in the municipalities. Again, that adds an additional cost, and so that's a decision you're going to have to make. Do we want to move forward and make this as easy as possible for the industry to operate here? Or do we want to make sure that at least our municipalities are not getting stuck with these gigantic projects where there's nobody there to take care of them? Then, as far as reclamation plans goes, you've seen them. Basically, it's everything that you've brought in, we want you to take it out, and we want you to restore to the property in the same condition as it was when you started the project. And that's the basic concept. But those concepts can be written into town laws as well, and some of the reclamation plans that you work on. A lot of the deals that we're seeing where they're signing these initial leases, the companies are not even coming to the property at all, right? They've got some office out west where they're looking at Google Earth, they're looking at all of your records at the county clerk's office, and then they're putting together a lease and putting together a general concept of where that solar farm is going to go. But there's no definite determination. In fact, that determination is not made until after they get into their due diligence period, and then what happens is they'll figure out, all right, we had initially thought we were going to lease 80 acres of property, but it now turns out that we're only going to lease 9.9 acres of property. Or 20 acres or 30 acres. And by the way, you know, we thought that we were going to put it over there near the back 40, but now we don't want to do that anymore. We want to put it over towards the front. And initially, right, if all of the property that you leased was included, all the property that you owned was included in the lease, then they have that discretion. The other discretion that they potentially have is for the easements, the access easements and the utility easements where they're going to need that to operate the solar array, right? How are we handling that issue? Are we handling that so that they have full discretion to do whatever they want and go wherever they want on the property? Or is there some mutual consent that has to be reached between the company and the landowner? That's the ideal scenario where you really want to reach that point where you've got some say in what's happening with that project. There are many other issues that we're addressing, things like chemicals. You know, we really don't want the company using chemicals for keeping down vegetation, so if we can get a provision in there that says, you know, herbicides, biocides, pesticides, that's great. Timber provisions, we seldom see timber provisions in the initial draft of the lease, right? And especially if somebody who has valuable timber, we want to make sure that issue is taken care of. Sometimes we see right of first refusal provisions in these leases. Those we want to get rid of so the landowner is not bound, and certainly we don't want to have the landowner stuck or impeded in any way in selling that property in the future. And sometimes those right of first refusals can impede some of those future sales. The tax issues we addressed, it's key to make sure that the landowner is not paying any of those increased tax assessments. Anything that's attributable to that project is a tax that should be paid by the company. Insurance indemnification is always a major issue, and we should be looking at the mineral rights and the right to be able to develop those minerals into the future, and those specifically have to be carved out of the lease. If you're negotiating it properly, those are things that can be accomplished, but you'll never see that in the first draft of the lease. So those are a lot of the issues that, as landowners, we're looking at. We looked to a lot of the municipalities to make sure that, and my goal anyways is for you to understand that those are the issues that we're dealing with, and then take that into consideration when you're making your decisions. Thank you.
A lot to think about, right? I know there's going to be a lot of questions. Our fourth speaker is Brady Begeal, and Brady is an attorney at Coughlin & Gerhardt in Binghamton, and he has a number of specialties in the firm that does a lot of work with municipalities, and has been especially working in the solar farm area. I believe, Brady, you're going to speak about land use and zoning, and what we saw recently in the Press and Sun Bulletin, questions about 487 of the real property tax law whether or not municipalities should opt out of that. So we're anxious to hear what you have to say about that.
All right, thanks a lot, Caroline. Yeah, so the two issues we're going to hit tonight, or at least I'm going to hit tonight, are the decision of whether or not to opt out of the tax exemption that's found in real property tax law, section 487, and then I'm going to talk about land use issues and zoning and planning. The first one, so let's go right into the first topic, which is the tax law 487. And what I want to do first is tell you a little bit about the exemption as it is before we talk about opting out. So in section 487 of the tax law, it says that if you're going to put a solar energy system on your property, or a wind energy system, or a farm waste energy system on your property, that you are automatically exempt from an increase in tax assessment on your property for that. It's not a tax, the whole property isn't tax exempt. It's just you're exempt from the increase in assessment that would otherwise result from those systems on your property. So that's the exemption as it stands right now, and that exemption will last for 15 years. Okay, and that lasts from 15 years from the date of the beginning of construction. Okay, so it's not a permanent exemption, and it's not even for the life of the useful life of the actual the systems themselves. As we've heard, that they can go 25, 30 years potentially, but the exemption only goes for 15. So that's what the exemption says right now. What's interesting is it's an automatic exemption as it stands right now, but there's a bit of a caveat with that. You have to file a form with your local jurisdiction. So let's say you're a property owner and you're putting a solar farm up on your property. Although it's technically under the law saying it's automatic, an automatic exemption, there's a filing form that you have to file with your jurisdictions saying, hey, I've got this project. It tells you when you tell them when it started. You tell them a couple of other pieces of information, and then the assessor knows that you're exempt. If you don't actually file that form, presumably the municipality doesn't have to give you that tax exemption, and I'm aware of a few that don't do that, which I think they have the right not to give that exemption if they don't get the form that's required. And it's a New York State form, it's not like a local form. So that's one little caveat to keep in mind. Another thing, that form actually has to be filed prior to the taxable status date, which in most towns is March 1st, and in the villages it's January 1st. So again, this is all brand new stuff as far as I know. I'm sort of researching this just like everybody else is. I would think that if you miss that taxable status date, you're going to be taxed that year for the assessment, the increased assessment. You'll be good maybe next year, but if you miss that date, you probably receive that increased assessment. So again, under the law as it stands right now, I want to talk a little bit about the pilot part of this, okay? So, and we learned this a little bit, we learned a little bit about what New York State thinks about this at this presentation that Scott and I were at the other day. And their theory is that, hey, this exemption, first of all, it applies to everybody, but if you want to carve out certain projects that you do want taxable, the way to do it is through a pilot, okay? So under the law, you can require any solar project or any wind project or farm energy project to pay a payment in lieu of taxes, which is basically a contract. And the way that process works is once the beginning of the construction occurs, they have to give notice to the taxing jurisdiction, okay? And then the taxing jurisdiction has 60 days to decide if they want to impose a pilot. That's basically all the law says. It doesn't give us a whole lot more detail on that. One thing that it does give detail on is what they mean by the beginning of construction. And guess what? It has nothing to do with construction. It actually has to do with when the contract for the work actually is signed. So let me just, and I want to make sure this is clear because it's important, I think. What it specifically says is construction of a solar energy system shall be deemed to have begun upon the full execution of a contract or interconnection agreement with a utility. And then if there's a deposit requirement in that contract, it's actually when that deposit's paid. So there may be a contract signed out there on a piece of property and you have no idea. But technically under New York State, that's the beginning of the construction for the project. So at that point, that's when the owner is required to notify the taxing jurisdiction. And then there's a 60-day period when you can decide whether or not you want to put a pilot in place. There's no guidance on the size of the project where a pilot can be required. As far as I know, under the law, you can require a pilot from everybody, including Joe Blow down the street who has just a solar panel on their house, which is bizarre to me. I don't think anybody would actually do that, but under the law, I think you presumably could. The time frame, the pilot, if you put a pilot agreement in place, it can only last for 15 years, which is the same period of time that the exemption would otherwise exist. Likewise, the amount you can collect from the pilot can't be more than the taxable, the increased assessment you would otherwise collect through taxes. So it all sort of makes sense. That sort of is something you would expect from this. What else? So generally a pilot, if you're familiar with pilots, it's usually like through the IDA, right? It's not normal that a town or a village is allowed to do a pilot. And I had one person ask at one point, hey, what if we opt out? Can we still do a pilot? Is it still an option? And I think the answer is no to that, because for towns and villages, pilots you're only allowed to do a pilot when it's required or allowed by statute. It's not something that you can just do by right. So this statute is the only authority there is that I'm aware of where you can do a pilot in this scenario. So that's the only situation where a pilot is available. One thing that's interesting about pilots is and that's unique from any other area in municipal law, is that you can treat properties differently. You know, if you've seen any of our trainings or any of our seminars, or talked to any of our municipal attorneys, they'll say, you know, you can't discriminate against properties. You have to have a rational basis for, you know, treating one property different than another. In this case, the way the law is written, you could decide and create a policy in your town or village that says, you know, we're only going to put a pilot in place for large-scale solar development, and we're not going to do one for residential properties. You can explicitly say you're going to treat this property different than that property. And again, this is all sort of new stuff, but that seems to be the consensus among the people I've heard talk about this. You can treat properties differently. And, you know, if you're not considering the opt-out and you're considering relying on the pilot program, that's something you really need to, that's probably one of the first questions you want to ask yourself. Where's the threshold? When do we want to require a pilot? Is it going to be a 200 megawatt or 200 kilowatt facility, or is it going to be a 1 megawatt facility? That's something you're going to have to ask yourself. Okay, so that's the law as it stands right now. If you do nothing else, that's what happens. There's a 15-year exemption. You can enter into a pilot agreement. What about the opting out? So all of the taxing jurisdictions have the ability to opt out, as far as I know. The school districts, the towns, the villages, and the county. And there's no requirement that they have to all do it or not do it. You could have 2 that do, 2 that don't, which could be fairly complicated for the solar developer if there's taxes in one and not in the other. For towns and villages, the process is adopting a local law. Okay, and all of you are probably familiar generally with the process for that. But you know, you propose the local law, then you adopt it. But as part of the adoption, you have to comply with seeker. Okay, although I don't think there's going to be too much of an analysis there. It's really just a tax law. And then you adopt the local law. One thing that's unique about this opt-out local law is that you have to file it with multiple different agencies. And hopefully, I would think that if you didn't, you wouldn't be fatal, but you know, you never know in New York State. But you have to file it with the Department of State, you have to file it with the New York State Department of Taxation and Finance, and NYSERDA. So all three of those entities. So that's just something to keep in mind, to remind your town clerks of if you're going to actually do an opt-out. The opt-out local law itself is probably going to be the easiest local law you ever adopt. It's going to, all it literally says is it just needs to reference section 487 of the tax law and say our town or our village is not going to provide an exemption under this law. It's in basic terms. If it says something similar to that, you've opted out. So it's a very simple local law. One of the big questions I've been hearing is can you opt out and remove the exemption for some but not all? Can you let's say you want to remove the exemption just for large-scale projects and allow the exemption for residential projects? The answer is no. Okay, I've got a resounding no from anybody I've asked so far, but There's no way to carve out the ones you want to have the exemption and the ones that you don't. Can you opt back in, right? If you, right now, the law doesn't make any mention of whether you can opt back in or not, but the rationale, as I understand it, is that it's just like any other local law. If you think that this local law is no longer important enough to have, you just repeal it, right? So, in my opinion, that's how you opt back in, is you repeal your opt-out local law. So I know some of the theory for some people in some of our municipalities is, let's just opt out, and then if we ever think that there's a reason to opt back in, we'll just repeal the local law. You know, and that sort of makes sense to me, although I don't necessarily know the implications of what that will do to the industry. If the industry sees a local law that's an opt-out local law, will they just ignore your municipality and move on to the next? I don't know the answer to that. And maybe Scott has a better sense for that, but the economics of this is really, really interesting. At this seminar we went to recently, they basically said the opposite of what I thought would be the case. They said that if you remove the exemption, it's pretty much going to make a small residential project infeasible to do. But if you, for a large-scale project, they may be able to overcome not having the tax exemption. Which honestly, I can't wrap my head around. I'm not a numbers guy, but you know, it remains to be seen if that's the case, and we'll see what happens. You know, obviously the pros, if you want to look at the pros and cons of opting out here, the pro is that you're guaranteeing yourself that if there is a project, it's going to be taxable, right? You're going to get the full tax assessment on that project. You know, and obviously the major con here is, the major negative is that you could, by doing that, inhibit the development in the first place. They may look and say, you know what, this isn't feasible, see you later, we're going to go to the next town that hasn't adopted an opt-out. So if you're looking to encourage it in your town, but you want to have the taxes, you're going to have to balance that scenario. Is it enough to rely on the pilot? Okay, there's a little bit of gray area with the pilots, but if you rely on that, is that enough to get the taxes that you're expecting to get? It's going to have to be a local decision that you have to make. The last point I'll make on this is the assessment piece of it. So I had mentioned before that you can the exemption only applies to the opt-out, the exemption only applies to the increased assessed value, right? Well, how do you assess the increased value? I know that I've talked to a few local assessors and they're still working on that. Some people think that there may not be an increased assessment. In fact, they may think that it's a lower assessment. The trend I've heard is that it should be given a higher assessment, especially in the residences, that basically the cost over time that you're gonna save on electricity, it should be a benefit and it should increase the assessed value. But I really don't know the answer to that, and I know that they've said that there's gonna be some trainings locally here coming in the fall, and I think there is some guidance online. But I really think that it's important for you to have a conversation with your assessors and have them get trained on this so that you can really understand the impact of what you do with the opt-out. And I think it's one of the most important parts of this decision is understanding the assessment. So, does anybody have any questions on the opt-out before I move on to zoning?
Can we opt out of only the solar farm projects and let the residents continue to enjoy that tax exemption?
No. No, that's
all or nothing at all.
That's correct, all or nothing. Yep.
But you could have a pilot for one that would give the same effect.
Yes, you can have it. So let me repeat the question. If you do opt out, it applies to everybody. If you don't opt out, you can choose to have a pilot with whoever you want. Now, let me just say one caveat with the pilot. While I said you can treat properties differently, you don't want to do it in an arbitrary way, right? You wouldn't want to say 120-acre project, yeah, we're going to force you to have a pilot. Oh, this one down the street, this 20-acre project, we're not going to have a pilot. I mean, that would be arbitrary. What I'm saying more is based, if you create some rational standard, anything over X amount of megawatts or kilowatts or whatever, that would be a rational basis, so.
Great. But what do we think, what do municipalities think about this? How much value is a property increased by rooftop solar? I mean, is that a major concern?
You know, I watched a webinar earlier this week, and again, take this with a grain of salt. This is not my specialty, but they explained that if you use the discounted cash flow analysis, they gave an example. They said the actual cost of a solar project for a residence would be $24,000. They said with all the incentives you can get right now, it would cost an owner in that situation only $6,216. And based on this discounted cash flow analysis, which is a method of assessing residential property, the value of the increased assessed value in that situation would be $9,000, according to this example from New York State. So, I mean, again, don't know how reliable that is, but that's what they're pushing as far as, they're pushing an increased assessed value for that. Yeah.
Brady, in Kirkwood there, we were considering opting out, okay? And until we know more about it, we can always rescind that later. However, about the residential, that we can't separate the two. Well, I'm talking to our assessor, and looking at other municipalities, that, and I think the lawyer just brought this up, it's so minimal, just leave it like it is. So they don't get taxed anyway. So you can still do the tax opting out of it and not affect the residential.
Yeah, so the comment was that if you opt out, it's not really going to have that much of an impact on residences because as far as the assessor is concerned, it's not increasing that much. Again, this is some confliction that I keep running into. Again, at the presentation we heard the other day, they were saying that it would become infeasible if you remove the tax exemption. But practically speaking, I know lots of people who are putting these up and they haven't even filed the certificate. They're enjoying the net metering that they're getting, and they haven't filed the exemption certificate. They're not receiving any exemption. Either A, they're not receiving any exemption, they're receiving an increased assessment, or the assessors just aren't imposing an increased assessment. So practically, I'm not seeing that yet, but maybe that's just as a result of the assessors not getting up to speed. I really don't know, honestly. There's a little bit of a discrepancy there which I think needs to be resolved. It's a critical question that needs to be resolved. And I wish I had a better answer for that.
Brady, I have a question.
Yeah.
Maybe this will just make it all foggier or not. But we've got a third thing in here. We're talking about rooftop solar, and then we're talking about these solar farms. The third thing is the thing that we went to on the conference the other day on, was community solar. Community solar is for people who don't have adequate roofs to put solar on. So somebody goes over here and they put in, I'm going to call it a solar farm, and they sell some of those panels to this person, some to that person, and some to that person. Do you have a pilot for that because it's like that, or do you treat it like residential?
I don't know the answer to that. My one thing I will comment though is I believe the reason why solar panels are taxable to the property that they're on is because they're considered a piece of the real property. I know that in other states, some other states consider them personal property, and there's debates going on in other states, and I'm pretty sure that it's clear here, at least in New York State as of right now, that it's considered part of the real property. So if it's not on the real property, I mean, you tax the parcel.
I'm talking about, do you tax this solar farm over here?
Oh, I would say, well, I guess my response would be yes.
On, yeah.
Yes, I think that because it's sitting on that real property, I would think so.
But if that municipality did not opt out, then there is no increased assessment for it.
Oh, right.
Wherever that farm is, even in the shared community solar program.
Maybe have a pilot.
Maybe.
Maybe. Right, maybe.
Well, doesn't zoning play a major role in this also? I mean, if somebody wants to put a solar farm on 100 acres and he's selling it, that's a business. He's running a business.
Right.
So zoning is plays a major role in this.
What a great segue to the next section.
Sorry.
No, that's good.
That was very good. It's almost like I planned it. right, so yeah, I'll get right into the zoning a little bit. You know, it's sort of reminiscent of the frenzy that fracking caused, you know, several years ago. And we had many seminars just like this. I think Scott and at least our firm, probably did no less than 20 over a couple of years. It's very similar here. So, but the discussions are very, very similar here, okay? You need to, the very first thing that needs to be done is you need to put people in place who are going to take a careful look at your zoning code, okay? Most zoning codes aren't updated that often, all right? It's costly to update your zoning code. You got to pay people like me do it. You know, it takes a long time to do, and it's costly. So you don't do it very often, usually, unless you need to. It's more reactionary, and it's just the way it is. So the first step that needs to happen is somebody needs to sit down, or a group of people, committee, maybe your planning board, your zoning board, sit down and really look hard at your zoning code. The biggest issue, if you take nothing away from the zoning piece of this, is you have to look at what are the permitted uses in your zoning districts, right? If you have zoning, okay, some towns don't, some villages don't, but if you have zoning, in most cases you break your town up into districts, okay? And in each district, there's a list of permitted uses. And a general premise, a general legal rule here is that if it's not listed as a permitted use, it's automatically prohibited, okay? So again, if you're not updating your zoning and if you haven't updated it to include a solar farm or a solar project or a wind project, and it rises to the level of a principal use, it's not permitted. You have a de facto moratorium going on in your town already. That's effectively how it works. I mean, somebody would come in and say, okay, yep, we want to do a project here. Oh, I see nothing in the code on it. Great. You know, that means I have free reign to do what I want. Actually, it means that you can't do it at all because it's just not a permitted use. So that's the first thing. Go ahead. Yep.
You couldn't request a variance?
Could request a variance.
Okay.
That's right. The applicant could request a use variance, but if you're on a zoning board, you know how difficult getting a use variance is very, very difficult to get. Really the first thing to do is look at your zoning code, find out what your permitted uses are, and figure out where in your town, in which districts you think that it's most appropriate to have solar. Okay, solar or wind, it doesn't really matter. So that's really the first big step. One of the other issues to look at is in most rural zoning codes, a district is, in any given district, you're usually only allowed to have one principal use, or I would say usually. In many cases, you're only allowed to have one principal use. So, for example, if you're a retail business, you can't set up shop as something else. You can't have a farm and a retail business on the same property because they're two principal uses, and that's usually a prohibition in most town codes. So where this becomes an issue is in the farming, right? If you're a farmer and your property is an agricultural zone and you're using it for a dairy farm, and you decide you want to section off a piece of it and lease it to a solar company for a solar farm, in theory that could be considered a second primary use, which is usually not permitted in zoning codes. So that's another critical threshold issue that you want to look at. How many principal uses do you allow in your districts, and should you create a special exception for solar? All right, so once you've kind of looked at your zoning code, you've just determined what the permitted uses are and how you have your district set up, that's obviously the biggest hump I think you need to get over. Then you start looking at how am I going to set up a permitting process. And at this point, I'm sort of assuming at this point you want to have some solar development. Okay, obviously if you don't want to have it, there's ways you can prohibit it, but I'm just going to assume going forward here that you want to allow it with some sort of restrictions and controls, because that's usually that's the purpose of zoning. There's kind of three ways you can treat solar development through zoning. And it goes from the most minimalist kind of point of view to the most strict. The easiest way to do it is just allow it through a building permit. You have them go through a building permit process, they get a building permit, and they can go ahead and develop. That's the easiest, most the process that's going to allow the least hurdles for the solar development. The next way would be just a building permit and then having them go through site plan review, okay, through your planning board. Most new land use activities have to go through site plan review, and that's where you can have them have to produce all of the things you want to see, the blueprints, the setup of the property, the setbacks, and all those things. And then kind of the next level would be having them require to go a building permit, having them go through site plan review, and then also requiring a special use permit, okay? Those are kind of the three options, going from least restrictive to most restrictive, and that's kind of your three options that you would really want to choose from. You'd want to come up with a fair permitting fee, okay, a fee for the permits, and you know, this is going to vary widely from residential versus commercial. In a residential situation, you're only really going to charge a basic flat fee, and in a commercial situation, you're going to want to really be prepared to have to recoup a lot of the costs that you may have to recover. The difficult thing about being on a town board or a village board is you end up having to be an expert in everything. You know, you have to deal with so many different issues, and all of a sudden, at the drop of a hat, you now have to be an expert on what's required for a solar farm. Okay. In most cases, you're going to need to hire someone, probably. If it's a significant enough project, you may need to hire someone to come in and advise you on that project. So that's something you want to make sure you have the ability to charge back to the developer, if you can. One thing I'll just mention, I won't get into too much about, is there's that New York State Unified Solar Permit, which is a fast-track way of being able to use the building permit process. I think it's for 12 kilowatt projects and lower, and I think that it basically makes the process only a 14-day period. You can get your building permit within 14 days if you use this process. So it's a way, if you want to, if you're really gung-ho about encouraging it in your residential areas, this is a nice way of doing it, is using their unified permit.
12 megawatts?
12, I believe that's right, 12
kilowatts.
I'm sorry, kilowatts. Kilowatts, yep. The other model out there that just came out at the end of May was the model solar local law permit, local law. It's for zoning. So they actually have a new model law that is a standalone local law that addresses all the zoning issues, okay? And it's a great start. It really is a great place to start to look at, because not only do they have the model local law, they actually give a nice little explanation of each section. So they have the section 1 with the language, and then they give an explanation of why it's there, what's the point, how you can actually increase it.
Where would I find this?
This is on, you can find this online. It's on the NY Sun. Does anybody know where you can find it exactly? And I've seen it online, but I don't have the site for you. But I know if you Google it, I'm sure you can.
Okay.
If you can't find it, email one of us.
Yeah, email one of us. So, you know, and I wanted to make sure I shared some comments on this, because I think it's probably going to be where most people go to start. My impression of it is that it's good. It's a very good start. Now, like I said, it's a pretty bare bones model, but they also have a lot of a la carte options that you can add if you decide you want to be a little bit more restrictive in certain areas. One thing I'll point out, though, and this has been kind of a key theme throughout, is the decommissioning issue, right? The reclamation. In this model local law, it requires the applicant to produce a decommissioning plan as part of the permit process. So you won't even get your site plan approval or your special use permit unless you come up with a decommissioning plan. You know, the problem with it is it doesn't have the security bond built into it, which really is the teeth for it. You know, you can't, if you run into the worst case scenario where the company goes bankrupt, that decommissioning plan is not going to mean a whole lot to that company unless you have a security bond. And if you have a really significant project, the cost of reclaiming the property, if you have to do it at the town level, it's almost impossible if you don't have a bond in place. So, you know, and I don't want to sound like the best thing to do is to put all these things in place, because at the end of the day, if you put too much in place, you're going to kill development. So one thing I know I'm going to try to educate myself on is what's the economics of this. If you require a bond that's got a premium of $1,000 a month, is that going to hurt how much is that going to hurt the project over a 25-year span? Is that going to kill the project? I don't know the answer to that. So there may be a bit of negotiation there on how much of a security bond you can actually pencil into this zoning law. So I want to hit on a couple of the issues, the big topics you want to hit in your zoning law. If you're going to update your zoning for solar development, the key thing, one of the key things you want to look at first is the definitions, okay? And most of the ones I've seen, most of the drafts I've seen, break it up into two things: small scale solar development and large scale solar development, okay? And there's a couple different ways you can differentiate between them. You can differentiate based on the purpose. Is the purpose of the solar system for commercial uses, or is it for strictly residential, okay? What's the capacity? You could differentiate based on a number. You could say anything under 200 kilowatts is considered small scale, anything over 200 kilowatts is large scale. So that's one way of differentiating. And the other one is, I think, is size. So you could say how many acres does it take up. If it's under 5 acres, it's a small scale. If it's over 5 acres, it's a large scale. And obviously, that's important because throughout the rest of your zoning code, you're going to want to include more restrictions for the large scale ones and less restrictions for the small scale. So the important part to look at first is the definitions. Another big issue, I think probably, I would say one of the biggest issues for I think a lot of our rural towns is going to be the visual impact of a solar farm. I know I've heard from a lot of people, very similar to fracking, I am going to be mortified if I see a solar farm in my backyard, right? Sometimes that's not something you can necessarily prevent, but you can mitigate that visual impact. You can mitigate it by requiring buffering, vegetative buffering. You can mitigate that by increasing the setbacks from the side of the parcel so that at least it's farther off in the distance. You can address the tilt that they put on the solar panels so that maybe the glare isn't going to be so bad to certain property owners next door. So there's lots of different things you can do. You can also address the color, the color scheme slightly to make it more conducive to the characteristic of the neighborhood. These are all things that you want to think about. If you really have a large project, you may want to require a visual impact study. Again, big cost item there, big soft cost for the company, but if it's a big enough project, maybe they can sustain it, and if it's important enough in your town, it may be something you want to include. I sort of just hit some of these, but property management, you want to look at the minimum parcel size that you want to allow certain scale projects. So you may want to say that all large scale projects must have a minimum acreage of 10 acres. Okay, and that's going to again reduce visual impacts and increase the safety of the whole project. Setbacks and buffers, we mentioned those. Safety, number of different safety issues that you want to look into. Fencing, do you want to require fencing? Mostly this is going to be large scale projects. How detailed you want to get in the fencing, that's up to you. But fencing might be a good idea. Warning signage, the distance between the ground and the bottom of the solar panel. Again, you have potential for vandalism, people breaking in, and is it going to be low enough to where they can get up and actually damage panels? And then utility lines. One thing you can control, or you can decide to control, is whether or not you want to require the developer to run the utility lines underground or above ground. I think in most cases they're going to be underground for solar, but maybe not, I'm not sure, but you may just want to focus on that. Stormwater drainage impacts. If you have a large scale facility and it's over 10 acres, you're going to have to do a SWIP and all that stuff, and it's going to be a type 1. It was 1 acre for a SWIP, 10 acres for a type 1, but stormwater drainage issues are something you want to look at. And I think some of the other environmental impacts were discussed already. Road preservation. You're going to see probably an increase in high frequency truck traffic initially during construction. I don't think it's something that's ever going to be a long-term thing. But on some of your local roads that aren't in great shape, could be an issue during initial construction if you have a large-scale project. So it's something you want to look into, maybe a short-term road use agreement requirement for large-scale projects. Fire and safety concerns. I think a good thing to do is to loop in your local fire departments and local fire companies. There's some unique hazards with solar panels. You have the electrical concerns, but then I think I've read some things where if they do catch fire, there's some inhalation issues. They release some toxic chemicals. My suggestion would be just, one, make sure that each site plan or each plan for a large-scale development at least has adequate access for fire and ambulance. And then also consider arranging for some training for your local fire departments. You don't want them having to deal with an emergency for the first time in a solar farm and not have any training on it. So just make sure you want to follow through with the fire departments. I think I already talked about the decommissioning. A couple more comments here. One thing that you don't want to do, this is something to more encourage the development and not put a roadblock up. In a lot of cases, codes will require the planning board to do site plan review. And some codes will require, if there's a special use permit, have the zoning board do the special use permit. Now, what's the problem with that? The problem is you're going to really duplicate a lot. I mean, they're not a whole lot different, the requirements for a special use permit and the requirements for site plan. If you make the developer go through a whole process with one board and then go through the whole process with another board, you're going to slow things down. It's going to be repetitive. It's going to increase cost for them. It's pretty much unnecessary. I would recommend, if you're going to put a process in place where there's a site plan and a special use permit, require that it only go through one of the boards. Generally, it's your planning board, but just something to keep in mind. And the last big point I'll make here on zoning is your comprehensive plan. Beat this issue up when fracking was big. We talked a lot about it. The reason why you need to look at your comprehensive plan is because all of your zoning needs to be consistent with the language in your comprehensive plan. If you have a zoning law that's inconsistent with your comprehensive plan, it's subject to challenge, okay? Your comprehensive plan is your long-term planning document. Every town and village is required to have one, although you don't technically have to have it in writing, but I think just about everybody has one in writing at this point. So you want to take a look at your comprehensive plan, make sure that's updated to address renewable energy, solar, so that you don't have a zoning law that's inconsistent with your comprehensive plan. I think that's my last point. Just quickly, I'll touch on moratoriums. If you want to, a moratorium is a way of holding the status quo and not allowing development while you are able to give yourself time to look at your zoning code. There's reasons why you may or may not want to do it. One reason why you may not want to do it is because they're often challenged and they're difficult to enforce. But if you really truly feel that there is an emergency in your town, you feel that that development is imminent, it might be a good idea for a short-term moratorium. But that's something you'd want to talk to your attorney about. Yeah.
What about noise levels? You know, they have these big converters that have to convert the energy because it comes out DC, it has to be converted to AC. I've heard complaints that those are quite noisy.
Yeah, so the comment was the inverters or converters are loud and noisy. That's a great point. And people wouldn't think that there's a noise concern associated with solar, but there is specifically that issue. Usually it's with the large-scale projects, but in that case, I think a few of the things you can do is you can require enclosures around it, require that to be the farthest, make the farthest setbacks for the inverters so that they're the farthest from the adjacent properties. And if you have a noise local law, that's obviously important. You can restrict the decibels and then put the onus back on the developer to come up with ways to mitigate that sound. It's the same thing with compressor stations that you may have dealt with, with the fracking. The compressor stations were loud, and I know that the industry came up with great ways to lower the noise. So, yeah.
I have a question. Both lawyers have given us a ton of information, all right? And that's good. My question is, in the Northeast, are there any other states that have the same goal and mission as Governor, except for New York State? And if so, why don't we pick their brain and see what they've done, and maybe what municipalities have done with all these issues that you brought up?
The question was, why don't we look to some other states in the Northeast that have already tread down this path, and can we get some information from them? I don't know, does anybody have any input on that?
If you go on the website, srectrade.com.
Say that again?
SREC, the Solar Renewable Energy Certificate, but SREC Trade is where these companies go to trade, buy and sell these things. And there's a map right on there, it'll show right up, and it's all up in the Northeast. I think there's 7, 8 states, something like that. So you can click on those and see, they're all different, they're all unique. Ours will probably be added to that map maybe next week, I don't know. PSC's having a meeting on the 15th, and you mentioned the Whitewater paper, and Whitewater.
See where your mind is.
It's getting late here.
But anyway, so New York may be added into that map. But there's, like I say, there's fewer than 10 states that are doing this.
Yeah, this is a pretty heavy push. I mean, I haven't been around that long, but this is one of the biggest pushes I've seen from New York State on anything in a while. I know I did some Googling and I found quite a few, if you're looking for an example pilot agreement, which I know I'm going to need to look at a few of them and develop a few of those. I saw quite a few in Massachusetts. They've apparently done a lot of pilots, and a lot of them were with wind, but I don't think it's that big of a meaningful difference as far as the pilot goes. There's a lot of good examples online in Massachusetts, apparently. So. Any other questions?
Yes. I think one of your other attorneys had mentioned some of the things that we'd like to include in the lease agreements with these companies, but we have a hard time doing that. Could some of those requirements, could we include those in our site plan review or permitting process? So we say we won't issue a permit unless you include these things in the lease with the landowner. Is that possible?
The question was, can we require things through zoning and require the developer to include them in the leases with the property owner? That's a great question. I don't have a great answer for that. I know that, we can require things in the zoning for the developer to do directly, but forcing them to put it into a contract, I doubt it, because that contract is a voluntary agreement, and if we were requiring that as a government directive, that'd be probably pretty overreaching. I doubt we'd be able to do that. What makes me nervous is that if Scott's having so much trouble getting a security bond through a lease, that makes me nervous. Why can't we get somebody to agree to that? It makes me nervous as to can we even get that, even from a municipal level? There must be a reason.
Well, part of it is that there are plenty of people signing leases without going to attorneys, without consulting with anyone at all. And putting that sort of town requirement that they provide that in a lease just wouldn't happen because they're not consulting anybody. But the companies are able to accomplish what they need to without anybody interfering. So they might as well do it. That's basically what the market will bear. Right? People are signing leases for $250 for the next 40 years. They're going to take it.
But if they have to have a permit and they don't get the permit, we can go tear it down and charge them for it. So that's so maybe they do it without knowing. Well, that's too bad. You need to get a permit, and we can have requirements in a permit that they have to live with or go someplace else.
For my purposes, I'd like to see the town requirements there as a condition of receiving the permit, and that would make me satisfied.
Okay.
One thing that's interesting,
we could put some of those requirements in that help protect the landowner. You think? Okay.
Yeah, one thing that's interesting is the model local law. This is something I learned from the model local law from New York State. Is one of the requirements they have is evidence that the landowner. You have to provide evidence that you are in consent with the landowner. Basically, that you have a lease in place. You're not going forward with this project without the consent of the landlord, which is an interesting requirement. I think that's a nice way of ensuring that at least they've come to some agreement before you allow this to go forward. Yeah, we'll go here first.
So the requirement, and this term in quotes coming down from our friends in Albany, is 50% of the energy requirement in 2030 must be satisfied through renewable resources.
Yes.
And what's the percentage today?
Well, it's supposedly it's 50% by 2030, but carefully they're only talking about the electrical needs based on our current use. What's interesting that
based on current use, not even future use?
Well, it's fuzzy, but the PSC white paper, they didn't address all these electric cars that are coming out. They got to be recharged with something. So they didn't have an answer for it, and they were asking the public to add in their 2 cents worth on that whole issue.
Well, irrespective of the cars, just the demands being generated by personal devices is going to drive that number through the roof.
It was just last week.
Actually, in the PSC white paper, they have a number, and I can't remember exactly what it is, in order to meet the demand in 2030 of conservation, including conservation. So they're actually saying in their white paper that by 2030 we're going to use less electricity.
That's
we're
interesting.
Going to use less?
Yes.
Less what?
BTUs. This is a completely separate
yeah,
issue.
I thought they were kidding too, but they're not.
They're talking a 23% reduction in BTU usage. I don't know how you do that.
Additional question with that? Is there in terms of this goal, is there a penalty associated with it too? Are they talking about penalties on? Oh my God.
Yeah, well, that goes back to the SRECs. the companies, they have an obligation to buy enough SRECs to meet their goal, whatever the state says it is. If they don't, and again, we don't know what New York is going to do, but some of these other states, they have what's known as an ACP, or some sort of compliance, alternative compliance payment, which is typically higher than what the SREC market is at. So in other words, if they don't buy enough of these, they've got to pay this for their penalty. But what's interesting is these SRECs can be passed on to the ratepayers. And in one state I know, the ACP, the alternative compliance payment, can't be passed on. So the company is going to be eating that. So sometimes they may be willing to pay a higher price for the SRECs just because they can pass it on. It's very complicated.
There's other components to the development over the next several years. So initially, it's going to be these types of solar plants, wind farms that are going to happen. And it's interesting, the ones that we're seeing, the companies have these requirements that you have to be a certain distance from the substation, you have to have three-phase, and if you don't have those things, then you're not going to qualify. But gradually, infrastructure will be increased. We'll have to see more transmission lines built. And then when that phase of that is done, they're also moving into an offshore phase. There's a lot more infrastructure that's needed for the offshore phase, but I've heard the state say that their intention is to move that towards the end of their goal, where they finish up satisfying a lot of their goals with that offshore component of the plan.
Okay, well,
Bob, you've got a letter up there you were going to talk to people about?
Yeah, well, when I get a chance, right. We're done, yeah.
All right, what else? Gordy?
I just have a comment. This is, what, 14 years from now, 2030. And like electronics, a lot of state-of-the-art changes. What happens during this 14 years of state-of-the-art changes? I know nobody has an answer, but something to think about.
demands for energy are going off the chart. I mean, and they're doing it, and it's 50% based upon current consumption. Wow.
Roughly.
Fuzzy.
Yeah. Now, they also wanted to get, this was just last week in the legislature, the assembly, they're trying to pass something for 100% renewables by 2050.
Jim, while I got your attention, I'm sorry, while I got your attention, what's the current percentage supplied in New York State now through renewables? 3%?
What do you think about 20?
Well, I know, hydropower in New York State accounts for 17% of our usage right now. And there's a little bit more with some of the wind farms and the solar stuff that's in, but it's only like another 3 or 4%.
3 or 4% is renewable.
Because of the hydros, New York State actually has a pretty good head start. And we've got a lot of hydropower.
Yeah, but that's kind of flat, isn't it? I mean, we're not.
Oh, no, it's flat. It's flat, right.
Okay.
That's not going to grow by
We're not moving.
Of the lights go out.
We have to pass a law that says you're going to, you can impose pilots?
No, you do not have to. The question was, do you have to pass a law to impose a pilot? No, you don't. You don't even have to adopt a resolution, as far as I know. You can just adopt a pilot specifically with that one developer that notifies you that they have a project. Now, I would recommend, though, that some sort of policy is developed, just so that you have a consistent approach with everybody. You may not have to do everything the same with everyone, but at least a consistent approach. And that can be done by resolution. It doesn't have to be a local law.
Otherwise, you're going to spend a lot of time in court.
Yes. Yeah, right here.
I just want to address some of the misconceptions that I've seen about solar that have been propagated here. The first of which was the solar incidence map that was shown. The world leader in solar energy is Germany. Germany has about the same solar profile as Alaska, if you think about actually the amount of light that they get. New York State as a whole gets 20% more solar energy than Germany does, so that's not as much of an issue as you may be led to believe. Also, the issue of the noise for the inverters, which is what converts the DC to AC power, as was brought up, even for a very large scale system, it's only about as loud as an air conditioning unit, about 60 decibels. So just a couple things
Is that dependent on how big the farm is?
Yeah, the bigger the farm, the louder they are, but they will never get louder than 60 decibels. And this is further brought down by how close you are to it. So you're not going to have this large inverter system in your home. You'll have it on the other side of your solar farm, so that the loudness is dissipated.
But they could be enclosed too.
Yeah, and they can be enclosed, and there's lots of other things that can be.
Yeah.
I'll make a short comment about electricity in Germany. He's right. Germans have more incentives than anybody else. They also have the highest electric rates in Europe. And the ratepayers, the actual people who actually pay the bills, are in revolt because they have the highest electric bills in Europe.
Yeah.
You touched on the infrastructure. Companies that are going through their due diligence, are you seeing them dropping sites because of lack of capacity, especially in the rural areas?
You mean capacity on the infrastructure?
Yeah, to accept the power.
We've been in negotiations on leases, and then, after several weeks, they'll finally get an engineer to take a look at the property and decide that it doesn't qualify. Because the strategy for some of the companies is to just throw the lease out there, and for $250, right, how wrong could they be? And then make the decision later on. But we're clearly seeing properties that are being dropped after they look at whether there's enough infrastructure to support the project.
Yeah, right here.
When you're talking about exemptions, and the ones that are due March 1st, which agriculture, we have to comply to that. I know that you have done this for years. Now, we get an exemption on our farm properties because we are in the ag district. But we also, to retain that exemption every single year, we have to prove that we have sold product worth $10,000 or more per year. So now these solar companies come in, and they're going to ask for an exemption. Are they going to, shouldn't they be made to say, hey, well, you're going to have to prove that you've produced X amount of dollars in solar power to retain that exemption? Because I have to do it every year with dairy products or animals or anything. I have to do it every single year. And if you have a bad year, too bad, guess what? Next 2 years, you're out your exemption.
Yeah, the question was, does somebody with a solar facility have to prove that a certain capacity to continue the exemption? No, not as far as I know. I just looked at the certificate today, and it's really just basic information they ask for. It's just informational, really. It really is no proof of anything other than you have to show how much it cost you, how much it,
So it can sit there and produce nothing and get exempt.
That's a good question.
Yeah.
Yeah, I don't.
I know I pay in land taxes, and if somebody's going to come in and set up something that large on me, because I own a lot of land, and he's going to get exempt, and then he piles up and says, well, we didn't make enough, this didn't work, and he walks away, then what's going to happen to the person that's
in that case, it wouldn't really matter because there'd be no increased assessment on a useless solar panel.
You don't live in Shenango County, do you?
Yeah.
This may be a silly question. All this electricity that's being produced, and I think it's a wonderful thing, solar energy, I've seen it work, I'm learning more about it, but I still have a lot of concerns. All this power that's being produced, is that going to, where is it all going? I mean, do they store it in some sort of batteries, or where does it all go?
Gosh, the question is, where does all the energy go that's developed?
Or do they shut off Niagara Falls for a while?
I'm not, this is not a technical, this is a more technical question that I don't have a great answer to, but my understanding is it gets net metered. I think you probably know more about this than I do. I think you talked about it the other day. But it basically it goes into the grid. I mean, unless you have batteries that are storing it. My old man has a small system that stores it so that he can use it when it's over the winter. But I think of the big facilities, I think that's just being pumped into the system for credit. Basically, right?
Yeah, yeah. Right now, our grid is really, really bad at storage, and it's something that will need to be accounted for by the utilities. There are some novel, cool ways to store electricity, such as using the current hydroelectric dams to essentially pump water backwards, and then as it's needed, it can then flow back down through the hydroelectric plant as a form of storage. There's also conventional batteries, but it's something that the utility will need to be able to take on if it wants to be able to keep up with these renewable energies.
Then there's additional cost.
Right.
Storage.
What's Germany doing, Jeff?
Fees will go up.
Germany sells it to the other countries around it.
Do they?
Yeah.
Makes sense.
Two issues.
Yeah.
The grid is not, sometimes it's there, it's always there to meet demand. All right? So they're not making electricity during night because we're all asleep. All right? But
Most of
6 a.m., the nuclear power plant that's on, whatever the base load is, they start adding in more capacity, and then solar comes on. Okay? But if you're making too much power, making too many electrons, you can't push it into a grid where there's no demand.
Where's it go?
Into the ground. To ground.
Okay.
There's just not enough battery storage to be able to handle it, and probably into the future, not enough lithium in the world to even develop lithium batteries to store it.
No, and New York Best in Rochester, New York, is New York's center for battery research, and they are going gangbusters, but we need some breakthroughs.
Yeah.
Have our environmental friends or anybody taken a look at how to address the problem of disposal of these things, since in fact landfills aren't taking them now, apparently from what you said, Jimmy said.
The research I've done, all they said.
What are we going to do with these things?
Just about every article I've read that said economically, landfill.
Do what?
Landfill. Throw them away.
There's no landfill in New York State that takes them, you said.
No, but that's, I mean, economically, they say that's.
Fine, that's great from that perspective, but is somebody looking at the long-term effect of those things being buried in the ground?
I have a problem.
We ought to inform our environmental friends to take a look at that.
One of the things when I was talking about early on about the environmental aspects of it, if the state did a generic environmental impact statement, that would be one of the issues that they would cover. They would have it done. One of the things that the Joint Landowners Coalition, we sent a letter, and I've got copies up here if you wanted to. We sent a letter to the Public Service Commission asking them to do a generic environmental impact statement. Now I know with the oil and gas stuff it took years to do, but with the amount of push that's being done for solar, I would guess if they actually did one, it would take them 3 or 4 months to have it done. I mean, there's no reason for it to take years, but it makes everybody's life easier. I mean, it makes solar power go forward easier. It makes everything easier.
If we have those letters for everybody here, it would be great if the towns actually did that, so that we get the state to do their job and do that environmental statement. That way the towns don't have to worry about it. It'll be all the same.
Sounds good to me.
It should be done.
Sure can.
I just want to mention, I wanted to let you know near the end that we're hoping to put on a program in the fall on wind farms. And if you're familiar with that, the Public Service Commission has a whole process. It's called an Article 10, and everything is laid out. And those of us that live in towns that have stone quarries, the whole long process with developing those and overseen by the DEC. And we know we're a heavily regulated state, but here there's very little, and it's like they're turning to the towns and saying, you figure it out. It just leaves a lot of questions as to why we don't have some regulations to help us when all these other areas do. I sort of turn to the lawyers on this, but it is surprising when you start to work with this. And wind is also going to become larger, so we want to present that in the fall. So you understand what an Article 10 is. And the good news is there is a lot of guidance there, which will help us. I don't know if there's any more questions, do we?
I understand that in Germany, they have 3 government facilities just to handle these, to recycle these panels. That's the way I understand it. My other question is, I also understand that the county is either in the process or already has, in the advertisement I see, set up, or in the process of setting up some kind of a solar farm somewhat, I believe, in the park system.
In the town of Conklin. Is there anybody from Conklin here?
Yeah.
My question is on that, is anybody familiar with the process that they've gone through in order to do this?
Yeah, it went through the Conklin, you know, it's a county project, and it went through the Conklin Town Board. I'm not sure what.
Not very much was done because it's county property. Right. It was pretty much a nicety that they came and told Conklin that we're putting in a solar.
It's a little different for the government project.
Yeah.
No, if it's a government project, you have the information on how this is being developed. Are they going through this process similar to what we're talking here tonight? Because that, if in the future that fails or whatever, that comes back on the taxpayer also.
And that's where, I'm not that familiar with the lease, but the county has negotiated a decommissioning plan as part of the lease. I'm not that familiar that I can cite the lease. You know, but that was separate from zoning, that was part of it.
Well, at this point, let's give a big hand to our presenters.